Number one, what I'm looking for, and I know you can only trust your instincts so far, but I've learned to trust mine to an extent. You know, might this person be innocent? You know, and so, I mean, honestly, there's some cases you go, give me a break. There's no way this person's innocent. This is crazy. They don't even say they're innocent, you know. And I look for and once again, this may not be fair because, you know, not everybody is as articulate or even literate, but is there an alternative narrative of innocence? And whether they can articulate it or not, can we see from the facts there's an alternative narrative to innocence? And if there is an alternative narrative of innocence that is, you know, inconsistent with the state's narrative of guilt at trial, is there a way it can be proven?
You know, sometimes the more outlandish, you know, the statement by the accused, the more curious I am about it, because if they were trying to create a narrative that was a reasonable explanation for the evidence, they wouldn't have come up with this. And so sometimes the more, you know, out of bounds it seems, the more I want to probe it through the physical evidence, because if they were trying to create a narrative, this is not what they should have settled on, so maybe there's something to it. You know, and the consistency of the narrative is something that, you know, you try to pay a little attention to. Because again, you know, when people are sort of will move the narrative like, oh, is that what the physical evidence said? Well, then maybe this happened. And so the story shifts. And so people who are really consistent with a story that, you know, might not make a lot of sense, but it's been what they've said the entire time, is something that I pay attention to. I say that's almost a theme in post-conviction cases, is that there's something about the story that, like, it begs you to look into it deeper.
There has to be a sequence of events that transpires that originates when a prisoner makes a claim of innocence to the point that would actually be seriously considered by the courts. And oftentimes what will happen is it will go to the prosecutor's office because their responsibility is to ensure the integrity of the conviction. So they have to be convinced that this claim of innocence is legitimate. And if they are convinced that it's legitimate, then they have to make the time and marshal the resources to set into motion the processes that have to take place in order for that to be brought before the court for the original conviction to actually be vacated. And when you think about the amount of resources that are expended, the finances, the personnel, in order to secure a conviction, or not even a conviction, just to go through a criminal trial, it's not a wonderful feeling for the court to say, oh, we have to go look at this case that was prosecuted 30 years ago with all of the other things that we have to worry about today and give this one our attention right now.
It really depends on what agency is looking and what their rules are. So some innocence clinics require that there be an actual claim of innocence, that the defendant has claimed all along the proceedings, been convicted, and never wavered, and is claiming that they are actually innocent of the crime. There are some innocence programs that will look for any type of error, right? If you have a post-conviction attorney and there's just a defendant on their own and they hire a post-conviction attorney, they will look through the trial record and look for errors, judicial errors, instruction errors, jury instruction errors, motions that were wrongfully admitted or denied.
Is there DNA to test? We you know, then that is a positive. We certainly do a lot of non-DNA cases. Our latest exoneration was a non-DNA case. But if there's DNA that might be a path to determining whether this person's innocent or not, then certainly we get enthusiastic about that.
What is challenging is the campaign that has to happen in order to convince the authorities to relook at a case. And I think what happens in some instances is that these authorities, they don't want it to be easy. to look at a previous conviction because they don't want to send the message to other people who are in prison who were factually guilty to think that this is just an easy thing to get a conviction overturned. But if they stick to it and the evidence is in the prisoner's favor, then an exoneration can happen, and it gives that individual who is actually innocent some hope.
You also have to look at practical things. I mean, has this person, as many inmates do, filed their own pro se writ? You know, they get frustrated, they file a writ. It's just, you know, handwritten on a piece of paper, and filed it. If they have, then under Texas law, they've given up their rights to contest. That's their one bite at the apple. And you say, oh, how is this a bite at the apple? Well, that's just the way it is. A card laid is a card played. And you go, well, this is not even a serious writ. This is just a piece of paper with writing on it, you know, that a frustrated, angry, innocent person, maybe innocent person, submitted to the court. Well, that's just the law. Now you've given up all your rights.
But you can imagine the difficulty if a person feels that they've been wrongfully convicted, well then shouldn't they do something as soon as possible, because every day they're incarcerated is a day that they've been deprived of the life that they were supposed to be living. And so you can almost appreciate the urgency that they feel, but I don't think they realize that if they write that brief too quickly, or if they write it ineffectively, meaning they don't understand the arguments and they don't write to address those particular situations, they actually harm themselves. Because what the attorney will do if they are represented, will spend more time to develop those claims more fully, find the right people, get them to contribute, and develop a much more well-rounded brief that addresses all the questions.
Craig Watkins, who had been elected in 2006, took office as the first ever African-American district attorney in Texas, certainly in Dallas County, but in Texas. And one of the first things he did is he hired a very good friend of mine, Terry Moore, to be his first assistant. She, after giving it a lot of thought, accepted the position. She had been in the Tarrant County District Attorney's office. She'd been in the U.S. Attorney's office here, and she'd been in private practice doing criminal defense for quite a while and really enjoyed that. So she really had to think long and hard about whether or not to accept that position. And she and I both remained living in Fort Worth. But she did, and then she came up with the concept of a conviction integrity unit because of Dallas County's history. And no one had ever used, as far as I know, no one had ever used the term before. We'd never heard it used before. We'd never heard of the concept before.
Not only are the development of post-conviction units and conviction integrity units and things like that important, but I think it's also important that those people or that those units have a lot of different skills in the office. And so they should have somebody with some real forensic background in them, because a lot of these cases revert back to the review of forensic evidence.
So we started going through the list of people who had asked for DNA testing but had failed at getting it for one reason or another, to decide, some of them you go and you go, I understand why this person didn't get DNA testing. There's no DNA in the case, whatever. It's an ag rob, there's no DNA, unfortunately. Or whatever, this, it's a murder case and their defense at trial was self-defense. It's not even, identity's not even an issue, that sort of thing. But we found some that we believed they should have definitely gotten a test. Patrick Waller was one of those. The crime involved two men. There were two perpetrators. The two perpetrators, two African-American men, abducted this couple off what was then called the West End in Dallas, which was kind of a entertainment party part of Dallas, the West End. And at gunpoint, put them in their own truck, in the couple's truck, drove them to an ATM, or had them drive to an ATM and empty out their bank account, then had them drive to this abandoned house off the R.L. Thornton Freeway. And they went to the basement of the house, and they were going to sexually assault the woman. And then it was kind of an interesting looking house for whatever reason, kind of an art decor house or something. And there was another, this is just odd, but there was another couple that were driving around the house just kind of looking at it. So one of the men went outside and took them, kidnapped them, brought them in, and they were going to sexually assault that woman as well. They did end up sexually assaulting the first woman. One of them did. One of them sexually assaulted the first woman. And then they got scared off something. And one of them went in the truck, and one of them went in the car the other couple came up in, and they stole the two vehicles and made their getaway. Patrick Waller was a young man on probation for possession of cocaine, felony probation. The police didn't like him. There's a couple of things that they thought he was good for, a stolen car or something that they couldn't get him for, and they told him, we're going to get you for something. We didn't get you for this, we're going to get you for something. And then within a week, the SWAT team had surrounded his house. They had decided they were going to put this case on him. Anyway, so he gets convicted. There never is talk of who the other person would have been. They were just sort of identified as the big guy and the little guy. And I think at that time, Patrick was the little guy, although when he went to prison, he bulked up quite a bit. And the little guy was the one who did the sexual assault. And so, therefore, he matches the sexual assault kit, along with 13% of the African-American male population, supposedly. And so why not test the DNA? Well, he lost his first time because they said, well, his actual charge was aggravated kidnapping and aggravated robbery for stealing the cars. It wasn't aggravated sexual assault. So it doesn't make any difference whether he's the one who sexually assaulted her, Now, that's crazy. I mean, that's a bad faith argument. But it won, and then he lost again, and he lost on. So we tested it. We had the Texas Department of Public Safety, who had all the stuff. We had them test it, and they tested Patrick's known sample. It wasn't him.
My name is Patrick Waller. I was tried and convicted in 1992 of aggravated robbery and 2 counts of aggravated kidnapping, and I served 16 years in prison for a crime I did not commit. DNA exonerated me on July 3rd of 2008.